All right. Well, by my clock here in Iowa, in Central Time Zone, it's 3:30 p.m. and on the East Coast, where Howard is going to be talking out of Eastern Mennonite University in his office, it's 4:30 p.m., so that means it's time to get going. So I want to welcome everybody who's gathered here in this virtual space to the I think what is it? It might be our 6th or 7th, maybe even 8th restorative justice webinar that we started this series last fall. And this topic, the topic of today's webinar, is victims' needs in death penalty cases. So we're excited to talk about a fairly serious topic within restorative justice. And I'll just do a brief introduction of myself and then talk a little bit about how participants can interact throughout the course of this webinar. So first, the quick introduction. My name is Brian Gumm, and I'm the Distance Learning Technology Analyst for Eastern Mennonite University. But I'm also a graduate of the Center for Justice and Peacebuilding, and my emphasis was in restorative justice, and so Howard was my professor and my mentor there. So I'm happy to keep helping out on the technology end of things, but I also have a keen interest and some experience in restorative justice myself. So this is fun work and important work even for me. So now a note about how to interact with us throughout the course of this webinar. The panelists, which will be Howard as the host and then our 3 guest speakers, all of us will have the ability to have video and audio, so you will see us and hear us throughout the course of this hour and a half we have together. And so you as attendees won't have that capability, but you can still talk to us and I want to draw everybody's attention down to the lower right-hand corner of the screen where there is a chat window. And you can type questions into that chat window, and I'll ask you to send them to a particular person, because one of the things you can do if you look in that chat window is you can select send to. And Jen Bricker, who is Howard's grad assistant, is going to be monitoring that chat. And so if you send any questions that you have over the course of the webinar directly to Jen Bricker, she will kind of collate those and then get those over to Howard, and then Howard will find appropriate points throughout the course of the webinar to kind of interject those questions into the overall conversation with our guests. So again, send any questions you have to Jen Bricker. If you accidentally send them to me, I will eventually see them and then forward them on to Jen, but get them straight to Jen. That's the place to send them. So that's all I have on the technology piece. So I'll go ahead now and turn things over to Dr. Howard Zehr. And Howard, you can take it from here.
Thank you. Thank you, Brian. And I want to add my welcome to Brian. So glad to have you with us today on this important topic. This is a field, we're going to be talking about a field of work which we sometimes call defense-initiated victim outreach. We're looking toward a new name for that. May change in the future, but it's pioneering work that has changed the way many people think about the death penalty defense and the role of those who've been victimized or survivors in that process. And today we have 3 pioneers in this field. Tammy Krause, who is here in Harrisonburg right now, and Dick Burr, who I think is in Texas at the moment, and Kelly Branham, who is in Nashville. Tammy graduated from CJP, was a student of mine, I'm honored to say, and really helped to pioneer this work. You'll hear more about it. She had both Soros and Ashoka fellowships that assisted her as she developed this work. She's now a PhD candidate at the University of Manchester School of Law in the UK, and she's focusing especially on the role of victims in justice, the history of how it got the way it is, and especially as the victim impact statements and federal prosecution. She can say more about that if she wants to in a bit. The second guest is Dick Burr, Richard Burr, Dick is an attorney who has specialized on death penalty defense issues and death penalty defense since 1979. He's highly regarded in the capital defense community. You go to a conference of defenders, death penalty defenders, they defer to Dick. His wisdom is highly regarded. He's done appeal work, he's done trial work, habeas proceedings. He's argued 2 cases before the Supreme Court. And he serves on the Federal Death Penalty Resource Council, which helps, among other things, to assign defense attorneys to death penalty cases in the federal system. Third is Kelly Branham. Kelly coordinates the victim outreach work for federal cases nationwide through the Capital Resource Council project. She's been an attorney for 25 years, working on death penalty cases in both federal and state level. She conducts annual intensive trainings for practitioners of this work that we will be describing. So, and all 3 of them I consider friends, and I'm just really pleased to have them with us today. So what we'll do is that we're going to hear from each of those and move through back and forth a bit, and then when they are done, we will open it up for questions. And as Brian says, if you'll send the questions to Jen, I will try to ask those questions in some kind of logical order. And we'll try to get through them all. We don't always, but we should have plenty of time. We will aim to have quite a bit of time to answer your questions. So I believe, I'm all the way here in the wrong event. Sorry about that. I got to go to the, here we go. So I believe, Dick, you're going to start, if I'm not mistaken. So I will turn it over to you.
Thank you, Howard. And thank you, everybody, for joining in this afternoon. The history of the DIVO began with the trial of Timothy McVeigh, or prosecution of Timothy McVeigh in Oklahoma City for the bombing of the Burr building in Oklahoma City. That event occurred on April the 19th, 1995. It changed history and sort of marked a new period of history for people in Oklahoma City and for a number of other people as well. The case was actually started trial on March the 31st, 1997. And I'll talk a bit more about what happened during that period of time and why it began to happen. But prior to the Oklahoma City bombing case, I myself had been a death penalty defense lawyer since 1979, about, I guess, 16 years or so. Had represented people primarily in what's called the habeas corpus process, which is after a trial, somebody has a direct appeal to usually their state Supreme Court, or if it's a federal system, to the U.S. Court of Appeals in their part of the country. And then after that, there is a habeas corpus process, which is a process by which cases are fully reinvestigated, and generally the claims that are made in those cases are that the defense lawyer provided ineffective assistance of counsel, or that the prosecution withheld evidence that would have been helpful to the defense, both in violation of the U.S. Constitution. There are other kinds of claims too, based on changes in law and newly discovered evidence, but those are the primary claims. And I've done mostly that work. I've done some trial work before the McVeigh case, but not much. But I was asked to become one of the trial lawyers for Tim McVeigh, and ended up being the person who helped coordinate the penalty phase of the trial for Mr. McVeigh. Prior to that time, like I said, I'd practiced for 16 years or so as a capital defense lawyer. I had never had any systematic practice of contact with survivors of the victims in my cases. I could only remember at that point having contact with one family of one of my clients. I was working in Florida at the time, and he was set for execution, and they had made some comments in the press at some point during the history of the case that made me think they might be satisfied if my client were not executed but spent his life in prison. So I went to see them. They were very gracious, and after talking for a while and reflecting about their daughter, who was the victim, simply said they were going to leave it in God's hands. And, I'd had encounters with survivors before that at hearings that happened in some of my cases. And, had not known what to say to people, had tried to be cordial, but was, I was not engaged, didn't know quite how to relate to people. And I think my history is pretty typical of people prior to the McVeigh case, defending folks in capital cases. What happened in McVeigh was, in part, a function of the enormity of the event. As most people may remember, there were 168 people killed in the bombing. Hundreds of people sustained serious injuries. The survivors of just the people killed amounted to nearly 1,000 people. When the bombing happened, I, like probably most everybody else in the webinar, was glued to the television. I was appalled. I was shaken to my core. I didn't begin thinking about it as a capital defense lawyer for a while. But when I did begin thinking about it, my thinking was different. It was that something has to be done about all this harm that was done, from the defense side. We had to do something about it. I didn't know what, but I came into the case with that instinct. And by about the middle of May, I was one of Tim McVeigh's lawyers, and was one of his lawyers through the end of the trial and through the direct appeal, and then again right towards the end of his life before he was executed. And I came into the case with that perspective. I found one other lawyer in the early stages who had similar feelings. But not until we got other experienced death penalty lawyers in the case did we begin to really think more about this systematically. Mandy Welch came in, who is my law partner and my spouse. A couple of other lawyers from Texas came in, and we were the primary people working on the penalty phase of the case, both investigation and preparation for trial, and putting on witnesses and arguing the case at trial. And we kept thinking we needed to do something, but were stymied by a variety of things. And not the least of which was that it was a bizarre idea to many other members of the defense team that we would think about wanting to do some outreach to survivors of capital cases. But at some point, we found out who Howard was. We invited Howard and his then graduate student, Tammy Krause, to come to Denver, which is where the case was being tried, to teach us and to help us figure out what we might do. It was only 3 months before the trial started when this process started. We spent 2 or 3 days with Howard and Tammy. We learned a tremendous amount, and out of that, we came up with a strategy for reaching out to a limited number of survivors. The government had given notice that there would be about 40 victim impact witnesses, that is, people who were survivors of people killed, who would be testifying if the case got to a penalty phase on behalf of the government. So we decided to make an outreach to those 40 people. We crafted a letter for me to send that expressed deep sympathy and said that we might meet in court and hated for that to be the first time, and would like to meet with them and try to answer their questions if we could beforehand, and that in order to make that perhaps more comfortable, we would have a person acting as a liaison between us and them, and that was Tammy. We introduced her. Tammy then followed up with phone calls to most, if not all, of the people that got the letter. And as a result of that, I, or some combination of us, ended up talking with about 4 or 5 people by telephone, not in person. And we were inquiring into making inquiry about the loss of their loved one, and tell us a bit about that person and a bit about themselves in the aftermath of the bombing. And most people were courteous, but didn't talk very long with us. We really didn't have much engagement, and we didn't learn very much. And the case went to trial. Most of those folks testified in the penalty phase over the course of about 3 days of testimony. We as a defense team had no questions to ask of anybody because we really didn't know people's stories very well. And it was very, very difficult to sit there to not be able to interact in any fashion and just to absorb the enormous grief and loss and pain that came into the courtroom through these innocent people. I sort of pledged to myself at that point that I wasn't going to have it happen that way again. If I was whatever kind of capital case I was in, and wanted to do something different. We stayed in touch with Howard and Tammy, and about a year after the trial, with Tammy and Howard's help, we gathered together with a group of about 15 or 20 survivors of the bombing in Oklahoma City and spent an entire day together talking with one another. And we learned a tremendous amount about what their interests were, what they wanted to know about, why the defense did various things that we did. We explained everything that we could. If there were some things we couldn't explain, we explained why we couldn't because of various attorney-client privileges or constitutional rights that we were bound to enforce. And we came out of that, the three of us, Howard and Tammy and I, with a deep commitment to develop this practice and to try to persuade colleagues in the capital defense community to take it up. And that was in 1998, and we began to do that gradually in federal death penalty cases, and I think Tammy will pick up our story from here.
Hello, everyone. So after Dick talked me into doing another federal case, I was very fortunate to get a fellowship with Soros Open Society Institute to try and create something different than what we had actually done in Oklahoma City. Oklahoma City was the impetus for thinking that we could possibly do something different, and out of that was born defense-initiated victim outreach. And what we were trying to create in that time of my fellowship was a way to have a principled approach to engage victims, the surviving family members, earlier in the capital case than we did in the McVeigh case. Some of the things that we learned in the McVeigh case were so instrumental that, like Vic said, we started doing outreach to family members weeks before the trial was to begin. And because of that, there wasn't a lot of time to get to know the family members, to foster trust. And what we learned the year later when we went to Oklahoma City to have that conversation, that dialogue with the family members, was that they had so many unanswered questions that they thought would be answered at a trial, or the trial created many more questions than ever could be answered. And I think we were all really surprised at that a year later, families were still holding on very actively to these sorts of questions. And what we realized is that if we were really going to create those professional boundaries or those professional relationships within the boundaries of the adversarial system, that what we needed to do was we needed to start as soon as we could, because there is a history of perception and reality that victims are mistreated and sometimes manipulated by defense teams. And we had a long history to overcome with that. And so, as most of you know, that the typical legal pattern that we have in our adversarial system is that it's become what can be done to the defendant. And even though we have the victims' rights movement that has really elevated the victim's status in the legal proceedings, it still focuses on what can be done to the defendant rather than looking at what the legal system should be doing for the victim. And we were really making up this work as we were going along, case by case, learning from victims who were willing to engage us. And learning from them what their judicial needs were, what they needed from the legal system, what they needed specifically from the defense attorneys. And so sometimes when we talk about the things that we learned in those first cases, Dick and I learned, the stuff was so elementary, and yet it still was a lot of aha moments in there. And so we were really trying to shift in capital cases from the very beginning of simple things such as when to introduce ourselves, when and how to address the victim. Oftentimes, both the prosecution and the defense would say things like the victim in court rather than ever naming the victim. And there was perceptions from both sides that maybe if they used the victim's name, that it would seem disingenuous or it would be an affront to the families, because how could the defense attorneys know, or how dare they use the victim's name? But it was only through engagement with actually learning through the families about their process and their experience that we were able to educate the broader defense community about how to make those changes that helped the families not perceive or experience being forced into a legal proceedings without it seeming to be harsh or adversarial. The system itself needs to be adversarial to protect the rights of the accused, but the system does not have to be adversarial towards the victim. And I think that our system, by and large, still has the victim caught in that vortex very much about the adversarialness. And I think what defensive-initiated victim outreach is about is creating a principled approach in which the victim shouldn't have to choose who they communicate with. They shouldn't have to choose sides or anything like that, and that all legal professionals treat the victims with the utmost respect. And part of that is meeting the victims where they're at and journeying with them along in the proceedings. And what that means is that many of you probably know from your work or maybe from being a victim of crime yourself, is that crime is really disempowering. And the legal proceedings are no different. If anything, the legal proceedings can exacerbate the experience of being disempowered. And DIVO is about respect, and it's about information sharing. And one of the things that we learned early on is that as much information as we could give to the victim, for instance, like when Dick was just saying, when we had that face-to-face meeting, even in the times when Dick said we couldn't share certain information because there was still an issue of attorney-client privilege, Dick and Mandy were able to still explain why they couldn't share that information. And that was still more information than the victims had before. And so with information, as you all know, victims begin to feel more in control of themselves and their surroundings, and that helped them to feel as though the legal process was attending to their needs a little bit, or that they even could understand maybe what was going on in the process. And so I think they felt a little bit more in control about their environment. And so the very beginning stages of DIVO was about the starting point of the both and within this adversarial context. The both and is on many levels. It's that the defense team can be concerned about both their client and the victim. It also means that the victim can be engaged and should be engaged with both the prosecution and the defense. And the reason for that is because both legal teams have access to information that's vital to the victim, but doesn't have the information that the other teams have, or it's not maybe in their interest as legal teams to share that information with the victims. But if we look at really rather, oops, sorry, my thing went dead. But if we look at the context of crime, instead of looking at a crime as the way Howard says about harm being committed, victims have questions and they have the need to want that information. And the defense is vital to that information because they have more information about the defendant than the prosecution does. And so the reason that we are starting to call it DVO instead of DIVO, which was the original language, is because, as Kelly will talk about later in the very shortly about it, is that what we have found in the last 17 years that we've done this work is that it's not necessarily defense initiated anymore. Victims are becoming very engaged and informed about their rights, and they're also becoming more engaged about knowing that they have access to the defense. And so oftentimes we're finding victims are actually directly approaching the defense teams to gather that kind of information or to develop that kind of relationship. So let's go to the other slide if we could. And then, so why do we do DIVO on capital cases? There's often a reason of asking people, oh, is this really just then about the death penalty, or it's just trying to get the victims against the death penalty, and it's not that. It has never been just that. That might be the motivation from defense attorneys at the beginning, but I think they begin to see the benefits to their work, to their clients, to the entire trial that they're doing, and I think that their perceptions change about the importance of this work. And so, as I said earlier, historically, victims were isolated from both the defense and the defendant. But then when we're slowly able to take those steps towards one another, I think that the adversarial or the fear factor begins to reduce. And I think that as a society, we owe everything to victims when they have been so tragically and horrifically harmed, especially as they've been in capital cases. And I think there is a long history of mediation and restorative justice practices such as circles and other things like that that happen in maybe lesser serious crimes, and especially in juvenile defendant crimes. But we didn't see anything as extreme or, you know, in the extremity of capital cases. And I found it to be really important to try and bring that level of restorative practice into capital cases. And one of the things that I think is really important is to say that defense-initiated victim outreach is not restorative justice. It has restorative elements into it. And Howard often talks about restorative justice as being on a continuum, kind of like the empty and the full. And really, instead of looking at it as empty and full, I just kind of look at it as, you know, little lots. And so, and every case is unique and different in and of itself. And so what it needs to do is that as much as it is desired by the victim, we are able to bring in restorative elements because it's always victim driven. It's chosen by the defendant or chosen by the victim how much engagement that they want. And so I think it's really important to bring in as many facets as we can, as long as the victim is engaged and is asking for that information. And ultimately, what this work is about is recognizing the humanity and the harm and the loss that the victim has experienced in capital cases, and that throughout the whole legal proceedings, victims can either be acknowledged with that kind of humanity, they can be ignored, which can compound their trauma, compound their pain, and make a situation worse. And I think as a society, we owe it to victims to do more than that. And I think that both legal teams, both the prosecution and defense, also have an obligation and a duty to do that. And I think that what we have shown in the last 17 years of doing this work is that in doing that, in creating respect for the victims, that it hasn't in any way taken away from the rights of the accused. It has just expanded the conversation and dialogue between parties who historically have not been a part of one another's lives. So I'm going to hand it back over to you, Dick.
Okay, thank you, Tammy. I want to talk just a few minutes about this from a capital defense lawyer's perspective. That's all I've been. I am not a victim outreach specialist. I have just been a lawyer defending people in capital cases for all these years. I've worked closely with folks like Tammy and Kelly and others who serve in a liaison role, but I'm a lawyer, so I'm qualified to talk about this. There are three reasons I think that lawyers that we have learned over the years and that we talk with lawyers about why we have to develop a plan to relate to survivors while defending a client in a capital case. First is what I think of as existential or spiritual, but I think in a sense existential is more defining. And that is, when I've come to understand, this is not an original idea with me at all, but that when a crime happens, an involuntary relationship is created between the victim of the crime and the perpetrator of the crime. In a capital case, those victims are the survivors, of course, and they believe that the person arrested and charged with the crime is the perpetrator. They believe that until proven otherwise. It's sort of the reverse of the presumption in court. And so there is this involuntary relationship. It's not conscious for most people. It's certainly not conscious in our clients, and it's not conscious in most defense teams, but there is that relationship. There is a kind of, for better or worse, magnetic pull between survivors and the people they believe responsible for killing their loved ones. Because of that, I should back up and say that's what I mean by existential. It's not chosen, it just comes into being when a murder takes place. Prosecutors and defense lawyers are not a part of that relationship. Nobody else is, except the survivors and the perpetrator. But because there is that relationship, the defense team, the team defending the client, has to be aware of that and has to try to act with respect and dignity and affirmatively on the basis of that relationship. And that, to me, is the most compelling reason why lawyers defending a person in a capital case have to do this. There is a relationship, and if they don't attend to that relationship, they have not attended to all of the aspects of their client's case. By 2003, the American Bar Association, which every now and then issues standards for defending people in capital cases, said there are two reasons that defense lawyers have to do this. They don't talk about the existential reason. They talk about good defense practice reasons. The first is that in the decision whether to seek the death penalty or not, prosecutors tend to listen most attentively to survivors. And of course, we as defense lawyers have to try to persuade prosecutors not to seek the death penalty in any particular case. So we have to be attentive to it for that reason. They also, as a consequence, if a plea bargain is reached or going to be reached in a death case, the survivors generally are going to have to be on board with that or it won't take place. The second reason is that survivors may be witnesses, just like all those folks were at the McVeigh trial. They may be victim impact witnesses. And if we know nothing about their stories, we cannot ask them questions. We can't take part in the presentation of that part of the case. And that's a powerful lesson. We know that for every survivor of a murder, there is a whole continuum of a story. There is the story of loss and suffering and enormous, acute, stabbing grief that happens when your loved one is killed and you learn about it. And then there is a long period where you're just awash in grief and loss, and life has been turned upside down. But there comes a time generally before these cases go to trial, where life begins to take hold again in the life of survivors, and little by little, in their own way, they begin to find a way to keep living and live with the loss and honor their loved one, but live their lives. And that's their whole story. And we need to know every aspect of that, because sometimes when they are put on as witnesses, they're only asked about part of the story. We need to know the whole story so that we can help them put it on, so long as they're willing to have us help them do that. And we can't do that without relationships. So that's critical stuff. I want to talk about two sort of barriers that get in the way of defense lawyers taking this practice on. First, I've called engaging in unconditional offering and responding. That probably doesn't make much sense, but here's where it comes from. We've learned that in doing outreach from a defense team to survivors, that we have to go with no agenda. Whenever we as lawyers go to witnesses, we are generally going with a very specific agenda, with a strategy for interviewing the witness, because we want to get something from them. We want to get information that we think they may have. And so we strategize, we go to them with a plan, and there's nothing unconditional about our approach to witnesses. This is an entirely different process. It is going to people who might be witnesses, but the purpose is not so much to talk to them as witnesses, but to offer a relationship with them. And it has to be absolutely unconditional for it to have any chance of being accepted. And we want it to take place because we've learned that when a relationship does develop between survivors and the defense team, it's both good for survivors and might be good for our clients. We can't seek it. We can't seek what we want from survivors like I did, years ago in the Florida case. We can't seek their help. We can simply offer a relationship. And if they pick it up and they engage with us and go back and forth in a process of asking us questions and us providing responses, a relationship can develop. But it has to be absolutely on their terms. And we as lawyers are not used to doing that. That's an unusual piece of practice for us. And that's hard. The second one is related to that, and that's letting the process take its own course. What I mean by that is I call my victim outreach person and I say, Kelly, have you had contact with Mrs. Smith? Well, yeah, I've talked with her on the phone. Well, what's going on? Can you tell me where she is? Is she going to help us? And Dick, that's not what the process is about. The process is about developing a relationship. Oh, yeah, I know, I'm just impatient. That's what I mean by letting the process take its own course. We are not patient people, we defense lawyers. I suspect prosecutors aren't either. We want results, and we want material and information and things to work with that will help our client. And even the best intended of us get impatient and try to push our victim outreach specialists to do things that are actually contrary to our ultimate interest, which is the development of a relationship, but we do it anyway. And so that can be a barrier. It can make some of this work hard from both the lawyers in and the victim outreach specialists in. Finally, these topics I call the hauntings: emotion, empathy, and loyalty to one's client. As all of you on the call know, there is an infinite amount of emotion that comes into being when somebody is killed. It is deep, it is wide, seems like it's going to be everlasting. It's volatile. It eats you up on some days and nourishes you on other days. There is profound emotion. And lawyers, even death penalty defense lawyers who do deal with emotion in the penalty phase of capital trials and in presenting our clients' lives in a humane and compassionate way, are not accustomed to the enormity, intensity, and quality of emotion that comes out when we have contact with survivors. It's scary. It shakes us. We don't know what to do with it. There's a part of us that thinks if I expose myself to that, then I'll start feeling more compassion for the survivors than I will for my client. The capital defense lawyers are generally pretty empathetic people, and people fear that. They worry about that. What we've learned in the process of doing this, and doing this in many, many cases, is though these hauntings may still be with lawyers, they are just hauntings, and they can be dispelled, because we just learned that compassion doesn't have limits. We can have profound compassion for the people that our clients hurt, as well as our clients and their families. Having compassion for one doesn't take away from the compassion for the other. It's a part of that both and process that Tammy talked about. And Howard, I think we're ready to move to Kelly.
Thanks, Dick. That was great, and I'm so happy to be here with you guys. I'm not going to talk too long because I think you all have heard from the primary people, really, and I'm going to talk to you a little bit about the state of the work today, and then talk about some of the challenges and the benefits of the work and what we're looking at moving forward. We've expanded tremendously in the last decade that I've been involved in the work. It began with the McVeigh case, and the primary work back then was at the trial level. And we've expanded now to having victim outreach in federal courts during the appellate process, throughout the habeas corpus proceedings. We've even expanded into non-capital cases, and I think that's very important to understand as part of the understanding that this work is not just in capital cases. This is not just about the death penalty, excuse me, but non-capital cases are beginning to utilize victim outreach, and I think that's critically important. We are now, I don't have an exact number, but we're probably getting close to having had victim outreach in about close to 200 federal cases. We may not be up to that point yet, but we're getting pretty darn close. But I think the most exciting way that this has expanded is something that Tammy alluded to earlier, and that is that victims are beginning to initiate a connection with the defense team. So in the past, we were saying defense-initiated victim outreach, but once it began to be victim-initiated, we thought, well, gosh, can we say victim-initiated defense outreach? That's a little bit of a mouthful, and it gets too complicated. And so we may be beginning to call ourselves defense victim outreach, because that sort of has both under the umbrella, and I think describes what's happening now pretty well. But not only are we beginning to see victims initiating this connection, but we're also actually beginning to see, just as an aside, victims who are initiating this connection also asking for the possibility of victim-offender dialogue in federal courts. So it's grown by leaps and bounds, and that includes the trainings that began when they began formally. They began at Eastern Mennonite University's Summer Peacebuilding Institute, and now they've expanded out into all corners of the country. We try to vary the trainings geographically to meet the need, because the need is nationwide. And so we've trained a large cadre of folks out there who were qualified to do victim outreach in federal courts. We now have over 70 people qualified nationwide to work on federal cases. We have a variety of languages included. We have Spanish speakers, we have French speakers, Vietnamese, we have Indian, Navajo even, and we've really expanded the variety of people that are coming to the training. We not only have lawyers like myself, but also ministers, counselors, even law enforcement officers have come through the training and are part of our group. Victim advocates have come through the training and are part of our group. But most importantly, even some victims and survivors themselves have come to the training and want to actually do this work because they've come to understand the importance of it. So it's expanded tremendously, and it's really, I think Dick talked a little bit about this, it's beginning to become the standard of care in many of these cases. Almost every defense seminar that occurs in the country, certainly on the national level, has a component of victim outreach on the agenda. And the American Bar Association, who has guidelines for the appointment of the performance of defense counsel in death penalty cases, actually discusses in their commentaries the necessity of approaching victims with sensitivity, and suggests using victim liaisons to defense teams. So it's expanded greatly, but of course with that expansion and evolution comes challenges as well as benefits. And I think one of the biggest challenges has been a challenge from the very beginning, and that is, how do you fit a square peg into a round hole? What do I mean by that? Well, Tammy described really beautifully how this work needs to be principled practice, and it has to be victim-centered and victim-guided, and it absolutely does. But how to move that forward while getting it funded as part of the defense function has been challenging. We've learned to refine the language that we use so that we can better educate people, including judges and others, how this can fit within part of the defense function and yet still be a principled victim-centered practice, but we've still got a lot of educating to do. And I think that includes educating ourselves as the defense community and as groups of victim liaisons doing the work. We continue to learn the most from victims and survivors that we work with. And that is obviously going to be something that happens on an ongoing basis. I think the greatest challenge that we face is due to the adversarial culture that we work in, and that all lawyers are educated into. That adversarial culture creates great suspicion and apprehension on the part of everyone. Defense attorneys are terrified of engaging with victims. Defense attorneys are often suspicious of prosecutors. Prosecutors are often suspicious of defense counsel. Victim advocates for prosecutors are often suspicious of defense victim liaisons. And all of this can lead to misunderstanding and attempts to block the work. Excuse me, that hasn't happened as much in federal cases as it has in the state projects, but wherever and whenever it happens, it's really unfortunate. We've had some success working across the aisle with prosecutors and victim advocates in various jurisdictions, but we need more. So that's something that we're looking forward to trying to make happen. I think we still need a better understanding that people can be zealous advocates and still be respectful and sensitive to the needs of others in the courtroom. You know, both sides, on both sides of the aisle have noble roles to fill, prosecutors and defense counsel alike. They both have noble roles, and they can be zealous advocates and move, but yet at the same time move through the process with sensitivity and respect. And that doesn't undermine their ultimate objective, it actually enhances it. So that's something that we're still, you know, we're still growing that concept. There have been, however, really dramatic shifts in attorney awareness and defense attorneys being mindful in how they move through the process in every respect, every aspect of the case, and being respectful to victims, and a greater understanding of how the trial process impacts victims. We've really, I think, garnered a better, greater understanding of how trauma impacts people in the courtroom, but most of all, victims. Of course, it impacts everyone. And I have to say the STAR program at Eastern Mennonite University that a lot of us have been through has helped us tremendously and been very instrumental in helping us understand trauma and its effect on both individuals and communities. And we draw on those materials regularly. There's much greater willingness on the part of everybody in the defense community now, as opposed to a decade ago, I think, to listen to victims and to learn from victims. And, you know, I've seen some really powerful things in the courtroom. I know that Dick and Tammy have too, and many of us have. It's really exciting when you begin to see defense teams understand the importance of addressing victims' needs and discussing their clients' obligations in addition to their clients' needs, and learning how community needs and obligations are appropriate discussions to have in their cases, particularly in cases in mitigation. So all that is sort of to say that in spite of DIVO resting smack in the middle of this really adversarial process, I think we see little nuggets of restorative justice along the way. And I think we'll continue to see little nuggets of restorative justice along the way in these cases if we stay true to the principles and practices.
All right, thank you, you three. Sujatha has a comment. She says, "You are all wonderful," and I will second echo that. She has a question for you, Kelly. Do you have any idea what percentage of cases are or inquiries are victim initiated at this point?
Well, it's definitely a minority still, but the majority is clearly defense initiated. But I don't have that off the top of my head. If I had to guess, I would say maybe 10%, maybe, but that's a shot in the dark right now, sorry.
But it's a shift.
Yeah.
It's an exciting one, yeah. Let me ask you another question, then I'm going to go to Tammy with one, and that is, how do you pick appropriate attorneys? I mean, there are some attorneys who are just not appropriate for this kind of work. How do you screen? How do you select? Because it's so easy to this could be misused, as you know, we've talked about often.
Yes, and that's an excellent question. And it's, and this is one of the tougher parts of the work, I think, and it requires people who do the work to really be firm and standing for the principles, and to be able to be firm and standing up to lawyers. And that's not easy for a lot of people. So it takes a real special person to be able to do this work. So there are times when attorneys want the work, and you always meet with them initially and go over the principles and parameters of the work and make sure that every member of the team, not just the lead counsel, but every member of the defense team, understands the parameters, the principles, and that it has to be that way, and everybody has to come to an agreement. There are times when we can use a memorandum of understanding. That's not always necessary, and it's not always a guarantee that there won't be an attempt at misuse. So what we often try to do is just really gauge and read people, get them to agree to the parameters of the work. And then if they're not willing to agree to it, then you just don't do the case. You don't do the work. And if anywhere along the way you find that the attorneys are trying to misuse it, you try to bring them back around to remembering the principles that they agree to. And if they don't, then, there are times when you may have to consider withdrawing from the case.
Thank you. That answers that question. The next question is actually, I have one for Tammy, but I'm going to wait because the question just came in that's directed to Dick. It could actually be directed to any of you. But Melissa asks, Dick, can you give specific examples of the kind of information that the defense can share prior to the disposition or conclusion of a case? And I might broaden that just a little bit further. What kind can you, and what kind of things do survivors ask for? What do they want, and what can you actually provide?
It's a great question, Melissa. I was actually thinking that was something we hadn't quite covered in our comments, so thank you for asking it. The questions come out of this involuntary relationship that's there between the survivor and the perpetrator, a person they believe is the perpetrator. So the questions often have to do with what happened, in detail, because the assumption is that the perpetrator knows and nobody else does. Why did it happen? Why my father? Why my mother? Why my sister? Why my brother? Why my uncle? Why? And those are sort of the beginnings of questions, because without answers to those questions, people fill in the gaps and infer what the answers are from the evidence that is available, and they become nightmares. And generally, the nightmares are worse than knowing the reality. The reality is terrible, but having the reality allows you to quit having the nightmares. That's one thing. And that can't always be answered, because we can't. We may know what our client has told us, but we may not be in a position to disclose it. And yet we know that is a critical need for survivors. And so it can become, one of the things that we do in capital defense is to work towards settling cases, to not going to trial, to have a plea bargain for a life sentence. And one of the things that we do and have become cognizant of in doing this work with survivors is, in plea bargains, to be sure there are provisions that call for, if the survivors want it, meetings with our clients at a time when they can talk freely and answer questions freely, and be asked any question of this sort, and not have adverse legal consequences to them from the adversarial process. So sometimes we can't answer those, sometimes we can, because sometimes the fact of our client's guilt is out in the open, and we can answer those questions. But those are some questions. Other questions that come are, why do you do the things you do? Various things. Why do you move to suppress a confession, or to suppress evidence, or to keep potential trial witnesses out of the courtroom? Those questions are frequent, and we can explain why we're doing that. We can explain, most people who find themselves in these circumstances have never been a part of a criminal prosecution or the criminal justice process, except, they've seen stuff on television. And So people don't know. So there are a lot of questions they have about why we do the things we do that they want to know about. They often will say to us, you know, why don't you treat me like this in the courtroom instead of like that? You know, when I come in and you know, you don't acknowledge me, or you nod, but then you don't interrupt what you're doing. Why don't you treat me as if I'm somebody who counts? That comes to us sometimes. In general, the last thing I want to say, and I'm talking too long, I feel like, but we don't in any way try to meet the needs of survivors that have to do with their needs apart from the criminal prosecution and this relationship between them and the perpetrator. We don't, we don't provide social services. We don't help them find financial help. We don't help them find counseling. We don't, we don't do that. It's not our domain. It is the domain of victim services folks and law enforcement. And we don't try to do anything except what is unique to the relationship between them and, at least putatively, our client.
Is it okay if I piggyback onto that?
Yeah, and then I'm going to ask you a question. Questions are coming in here, so yeah, go ahead.
Well, the thing that I wanted to say, that often as a victim outreach specialist, when we are working on a case with defense attorneys, and victims will ask questions to us that they want us to ask the defense attorneys, what we often say is kind of a guiding, a rule of, a guidepost, is that when I talk to someone like Dick, for instance, I'll say, what is the gray area? And the gray area is really, by answering this question that the victim has, will it in some ways jeopardize your case? If the answer is yes, it will jeopardize the case because of the things that Dick just said, then at least give me an answer that I can give to the victim of why you can't answer this question. But if the answer is no, it won't jeopardize the case, then that's the wiggle room. And both Kelly and Dick talked about how oftentimes, because of the adversarial mindset that's just been so entrenched in people, there's this idea of give nothing. And yet what victim outreach can do is it's providing this, like, back up. It's not a give nothing here. Where's that gray room? And if it's the gray room is no, it's not going to jeopardize, then why won't you answer this question? And so that's often what we can do. That's the interplay that I think is the most exciting. And Kelly talked about where you see a lot of shifts going on with the defense attorneys, is that they begin to start becoming aware of these, like, hey, I can share that with the victim without even the victim asking that question. There you go.
All right, there's more we could say about this, but we'll move on with our question. Lori's asking about timing, and any of you could answer this, but Tammy, I'm going to ask you this first. Can you address timing? What are you hearing from victim survivors about the appropriate time to contact survivors, especially in a pretrial context? So what can you say about about timing of contact?
I think that, Lori, thanks for your question. I think that every case is unique, and you can't say this is a strict approach to taking things, but I think as a general rule of thumb that it's very important to remember that after horrific circumstances such as murder, you don't want to be trying to create a relationship or introducing yourself to victims, because trauma is so overwhelming, and then it's isolating, and then it's numbing, and it's everything all at once, and it's very messy. And the last thing that we want to do is intrude in that space with the idea of somebody who is somehow directly or indirectly related to the defendant, the accused, of creating a relationship. So with that, the earliest I would say is 6 months out, because you need to let people have a period of wrapping their head around, just the loss by itself before they can even get into the idea that they're going to be within, the legal system. But I would say the best would be after a year, because you need to be aware that families need to deal with a year of a lot of firsts. The first Christmas, the first wedding anniversary, the first anniversary of the person's birthday, their death. And so, we would say, if you can, wait a year out. But like I said, there's not always a hard and fast rule with that.
All right, thank you. Kelly, let's go to you with this one. You're an attorney. Angie asks, what keeps this from being witness tampering or potential grounds for an appeal?
Well, I've never known it to be potential grounds for an appeal. I'm trying to imagine how that could come about. It's not witness tampering because, first of all, you're not trying to influence a witness and you're not trying to intimidate or coerce a witness into anything. And so it actually, because victim outreach has been developed as such a sensitive, respectful, cautious approach, really, it's almost like the most, if it's done in a principled way and the way it's supposed to be done, the most you could be accused of is how dare you be nice to the victims? How dare you be nice and respectful to the victims? That's not to say that people aren't going to, think that just because you're from the defense team, you must be up to something. That kind of goes to the adversarial culture that we're in that I talked about before and how just suspicions are automatic. And that's why I think the work just has to be so cautious. So it's not witness tampering because you're not tampering. And Dick may want to chime in on that too. And I'm just unclear about how that could end up becoming part of the appeals. But
Well, and you do try to be transparent about it, and often the prosecution knows you're making this contact and so forth. Or sometimes they're more happy, sometimes they're not happy about it, sometimes they are. And I know there have been situations where the prosecution has thanked you for doing this. So
yes,
you get all
absolutely.
kinds of.
And another thing is, of course, when we make outreach to victims, if they decide that they don't want anything to do with us, of course we respect that. And the only thing that I think it's important for us to continue to do is to let them know that we're going to remain available to them throughout the process if they change their mind. Because also we find that during the process, even if they initially reject any communication or engagement with the defense team at the outset, very often they'll change their minds during the process when something comes up and they think, oh, okay, now I have a question, or yes, I want to voice this concern to you. So, that's also it.
All right, thank you. Dick, let's go to you. Again, all three of you could answer most of these questions, but this one is a defense question. So Bethany asks, how should the defense team handle situations in which survivors are asked to meet with their client as a part of a reconciliation process while post-conviction litigation or clemency is still pending? How should the team balance the benefits and risks of arranging a meeting during post-conviction litigation or clemency?
It's a tough question, and I think I don't want to dodge it, but I think it so much depends on the circumstances of your case and what's being litigated. You also, of course, when you're in post-conviction, have to keep an eye on the possibility that you may actually win a new trial, and you have done something that compromises your client's rights in that respect. So you have to be cautious, and I understand your question to be one based on caution. But the challenge of this work is to always recall that, at least in the minds of survivors, there is this relationship there. Again, I don't think many of them would say, I have this relationship, I'm acting on it, but it's there, and it's what makes them want to talk to our clients and find out what happened and why they did it, and express their feelings about it. And so there is that tremendous need, which can actually have extraordinarily transformative qualities to an entire case, and you balance that with protecting your client's rights, being a zealous advocate, providing effective assistance to your client, and you try to take each request as it comes within the context of the case, what the issues are, and whether you can take any step in the direction of really providing what the survivor wants. It may be that the best you can do is explain why you can't do it. But what Tammy and Kelly have both said is that, and I as a lawyer know this, that it stretches us. It stretches us beyond our instinctive feeling that we can't do something. We have to do it thoughtfully and mindfully and try not to make mistakes. But it is a legitimate pull to have on us within the context of representation.
While you're on, Dick, can I ask another question that kind of a defense question? Scott is asking, he'd like to hear the thoughts about the possibility of extending DIVO work to include facilitating possible connections between co-victims / survivors and family members of the defendant. So connections between the victims or survivors and the family members of the defendant. It seems like defense attorneys would be well positioned to do this. Is this a feasible outgrowth of DIVO or DVO?
It is. I don't think we've given the kind of systematic attention to it that it deserves. And in fact, often that begins to happen between families despite us and despite prosecutors. You know, I think that there is a kind of empathy between the families of murder victims and perpetrators or accused perpetrators. There's empathy for each other because they realize neither wants to be in the circumstances they're in, and both wish they were not. And there are a lot of stories you hear of, you know, moms meeting in the bathroom and coming out arm in arm crying, and you know, there is an extraordinary underlying relationship there too, I think. And I'd like Tammy and Kelly to speak to that too, because I've known about it happening. I've seen it happening in some cases that I've worked on, but I think they might have better insight about how much facilitation we've been able to do with that.
All right, there's one of you. We have another attorney kind of question, but let's go back to Tammy and Kelly. Does one of you want to pick up on that?
Yeah, I don't know if Tammy's going to pick up on it. I'll say briefly, I don't think what I've witnessed, and I think I said earlier that we've all witnessed some very powerful things both inside and outside the courtroom, and some of that has included interactions between victim families and defendants' families. But I must say that at least in the cases I've been involved in or been a direct witness to these interactions, I've not been in any position to formally facilitate that. I can also say that given the principles of the work, it would be inappropriate for us to attempt to facilitate anything that was not initiated by the victims, because this is victim-centered and victim-guided, even though that is often an automatic, inevitable relationship, and it may unfold in an organic way through the process. I think with victim outreach, unless this is something the victims want to happen, I don't think we can be in the position of formally facilitating it.
Well, and am I not right that when people ask for a meeting, a facilitated meeting, survivors and offender, that you don't do it? You call in a specialist in victim offender dialogue who is more neutral in the process. Is that right?
That's right. And now we've seen an increase in the request for that with the victim offender dialogue. And some of us have had trainings. We realize that's a very separate role, and you can't play both roles within a case. So it's important for us to understand the profession and the principles of that work, and understand the difference, and also to know that we're not in a position to facilitate that as victim outreach people.
And one of the challenges has been that there's many people now in the United States who are trained to do victim offender dialogue, but most of them don't have the understanding of the legal complexities of a death penalty case. So it's not that easy to find people often for that.
Right.
Yeah.
That's correct.
Let's go to Dick for this question. If the defense would not be in favor of mediation dialogue post-conviction, how are they addressing the request mentioned earlier regarding victims asking for this prior to trial? Is that question clear? That comes from Angie.
Yeah, I mean, again, it kind of depends on the circumstances of the case, Angie. If in some cases where there is a confession, there's either no challenge to it, or let's just say there's no challenge to it. There's no grounds to challenge the confession. There is evidence that confirms and corroborates the confession. So there's virtually no question about guilt or innocence, and the case is all about what punishment will be inflicted. In that kind of case, I think many lawyers would feel, some degree of comfort with engaging, allowing a process of contact between survivors and our clients to take place, again, in a kind of controlled and facilitated setting with some pretty clear ground rules. But in that kind of case, it can happen. In what is probably, I don't know if it's more typical, but a case in which there is some question about guilt or innocence, and those issues are going to be tried, it can't happen. I mean, there can be, there may be some insight into the evidence that can be provided by the defense that may be different from the insight provided by the prosecution. And defense teams can respond in that way. But part of the response would in that kind of case would have to be to explain why at this point in the proceedings the defendant's constitutional rights and protection of them prevent a direct answer to that question.
Okay, thank you. We have a quick question from Kristen for Kelly. So Kelly, can you say a bit more about outreach to victims advocates within DA's offices? How does this work traditionally? How has it traditionally been presented to them, particularly at the state level? And how are you and others working to overcome the resistance to this program? So the question is to you, Kelly, and it has to do with approaching the prosecution, how you present this to prosecutors and DAs.
Right. And she asked about state programs too, and that's something I can't speak to because I help coordinate it in federal courts. And because in the federal system we have jurisdictions nationwide, and we don't know the players in each jurisdiction. We approach it on a case-by-case basis rather than having a uniform approach, and we have to leave it to the defense teams how and when to do that. So there is no blanket uniform rule in federal cases. When we have approached prosecutors and victim advocates, there have been times when they were receptive to it, and there have been times when they are not. I think the best approach is one where we can offer ourselves up to sit down with the prosecutors and the victim advocates so that they can ask us anything they want about the program, and we approach them with open hands, just the same way we do victims and survivors. And sometimes, it'll be important to offer to victims and survivors in the initial meeting that if it makes them more comfortable, we're more than happy to meet with them in the presence of somebody from the prosecution team or the victim advocate team. But it really varies from jurisdiction to jurisdiction.
All right, thank you. And I should say that today we're focusing on the federal level and the team that's kind of overseeing that. There are others, teams, Pam Leonard, Marilyn Armour, others working on the state level on these issues, on this approach. Kelly, while you're up, Sarah is asking about trauma. You spoke about the need for trauma awareness. How is this incorporated into your training, and how does it extend to defense attorneys? Is there room for conversations about trauma awareness with defense attorneys?
Absolutely. And one of the ways we train defense attorneys about why they need to begin caring about victims and treating them with sensitivity and respect and meeting their needs is that, what we've learned from the STAR program is, and these are graphics that I use on a regular basis when I speak at conferences, is a lot to do with the victim offender cycle. And when people who have suffered a profound trauma don't get their needs met, don't get the resources they need to work through it in a healthy way, the world can become not only a more dangerous, fearful place, and a lot of bad things can begin to happen to them in their daily lives, but it can also begin to make them see the world in black and white in very rigid terms. And that's something that I've seen for all the years that I've been in the criminal defense realm. I've seen that with attorneys. You take a capital case and you have everybody in that courtroom riveted with horrific facts and horrible photographs. not only is obviously the most profound trauma that's going on in that courtroom happening to the victims and the surviving family members of the victim, but everybody in that courtroom is impacted. The attorneys, I think the prosecutors are impacted, the defense attorneys, the judge, certainly the jurors are impacted. And you know, we've seen this time after time, and in a profession where you do these cases day in and day out, and you're continually you know, enmeshed in these horrible, horrible circumstances, looking at autopsy photographs, listening to the testimony. Every aspect of it is traumatizing. And I think it's harmful to everyone in the courtroom, most specifically, of course, the victims. But the more that defense attorneys can understand the impact of trauma on victims and how that affects them moving through the process of the case, it's going to help them understand that it's actually part of their effective representation to be addressing the needs of victims. And also, I think they need to have more insight into how trauma that they're enduring in doing these cases day in and day out is impacting them.
So there is a star training watching this today, going on right now, watching this. So we say to them, take this back with you. So,
absolutely.
There's a question for Tammy now. Tammy, I don't know how much you can talk about a specific case, but Sujatha is asking whether you could talk about the Vermont case, between the connection between the surviving mother and the defendant's wife. Sujatha was in an unusual position to observe that, since she was the law clerk for the presiding judge on that particular case. But Tammy, are you in a position to talk about that at all?
Sure. It's thanks, Sujatha. I would actually really like to hear from Sujatha in regards to her perception of it, because I experienced it very differently. I think it goes back to the question that somebody had asked earlier about how can you create those relationships. And I think Kelly rightfully said that that's not the position of the victim outreach specialist to create, you know, or to try and create that relationship. But what I have seen on an overwhelming number of my cases is that when you meet the victim where they are at, without the agenda of trying to push them into understanding the client or the family or justifying anyone's behavior or anything like that, I think if you go to the trauma aspect of what you all have been talking about, is that there's an aspect of victims are trying to make sense of the senselessness. Like, if I could only understand X, like why this happened, maybe it will help me understand or contain, as Dick said earlier, you know, to try and contain the images or the memories of the foster certain things. And that's exactly what happened in the case with Christine. The mother was a woman named Sheila Rockwell, and throughout the process, she didn't care at all about Christine. I need to say, her 17-year-old son was killed by a pipe bomb that was UPS overnighted to him, and she happened to be in the doorway when Chris opened the package. The two Chris's, both the deceased victim and the defendant, and Sheila happened to be in the doorway when he opened the box and the bomb went off, and she was grievously injured herself. She was in the hospital for over 6 weeks. And so you can understand not only tragically losing her son, but having to grieve him while she was in the hospital herself. But through the process of just her asking the questions and meeting her where she was at, she had no care for Christine, the defendant. But what we did see is she started to ask questions about his life and about different things. And at one point, this was a case, as Dick had mentioned earlier, that if we work towards actually trying to really meet the victim's needs, the way that we can be most successful with that is through a plea agreement, because we can directly address the victim's needs in a plea agreement as parameters for the plea agreement. And Ms. Rockwell, that's one of the things that she came to want to do, was have Christine, the defendant, directly address a lot of the things that she was doing. And he agreed to those things, I mean, overwhelmingly. I mean, we shot the moon, and he went for all of it and agreed to everything that she had wanted. And during the sentencing hearing, after the plea was done, Judge Sessions had a sentencing hearing, and Sheila still wanted to make a statement, and she made a statement. And as she passed the bar, to go back into the gallery, Christine's wife was sitting directly behind Christine, and Sheila stopped, and Christine's wife just held out her hand, and Miss Rockwell took her hand, and the two women stood there holding hands, and the whole court was paralyzed, like dumbfounded. You know, nobody, I mean, the session couldn't keep going because they knew that it was the defendant's wife and the victim's mother was standing there holding hands. And so finally Judge Sessions was smart and called for a recess, and the two women went out and had a smoke outside.
So we have just about 5 minutes before we need to start winding up. Tammy, I want to ask you a question that you hear a lot, and that is, why should this person be situated with the defense? Why are they not sort of out in the middle without taking sides?
Well, I think that you mean, are you saying specifically about the victim outreach specialist, Howard?
Yeah, some people have asked that, and we've often talked about that. In the ideal world, where would this person be, and why are they where they are now?
Right. And we do go back and forth on should there not be a victim advocate or a victim outreach specialist with either the defense or the prosecution? Should it be a more neutral role, maybe through the court system? And I don't know, oops, sorry, we are good. I don't know necessarily where I stand on that on a day-to-day basis, because I see the benefits of both. And I think that right now, as long as we are in this adversarial context, and there's reasons for that that have been laid out already, I think that it is really important that there's that both and, that you have the victim advocate from the prosecution and you have the victim outreach specialist from the defense. And the reason for that is because there is an irretrievable brokenness I said the wrong word there. There's a brokenness that has happened between the defendant and the victim, and that relationship with the defendant is isolated in so many layers of protection that it is only when the defense teams understand the process, respect the process, are they able to create situations in which that information, that vital information that the victim is wanting, can be revealed to them. We always talk about it as kind of this organic relationship has been created because of the crime. And whilst the prosecution may have even a taped confession and photos or ATM video clips and stuff like that, it still doesn't answer a lot. It's not able to answer a lot of those why questions of trying to make sense of the senselessness that the victims want, that we're trying to help in this process.
There's one more question, if you can answer it in 3 minutes, and that is, Angie's asking if it's a confidential question to victims, for you to be able to tell a story like you just did. Do they sign a release of some sort, or do you have some kind of agreement with? I sort of paraphrased your question. But how do you decide what you can tell and what you can't?
Right. In this specific instance, that case happened 15 years ago, and Ms. Rockwell has given me permission to tell that story. She has actually been at a conference before with me and was able to share the story. So thank you for that about the confidentiality. But I think one of the important components to know about the work that we've created within the federal system is that we're always very clear with the victims that we don't have confidentiality with them, because we are working at the behest of the defense teams. We are not an integral part of the defense team. We're hired like an expert as the liaison to go out and do things. And so we're very clear about not being able to share or have confidential information shared with us, for the fact that we are actually trying to protect the victim so that they do not feel in any way that we have taken advantage of them. And so I think that there's a difference. There's definite need for, in victim services, to have that confidentiality where it comes to community victim services like rape and domestic violence, but that's not the work we're doing. We're always very clear that we're there at the behest of the defense.
All right, thank you to all of you. This has been really very informative, very eloquently stated, and I'm very thankful for your willingness to be on today. We're in the last few minutes here. Excuse me, Jen Ricker is going to tell us a little bit about what's coming up in the future. She has just moved to Washington, D.C., and for some reason we can't get her video on, so you're going to only hear her voice. She said she just moved today, so she seems to think that's a good idea. I thought she'll have to answer to that one. But Jen, tell us a bit. This is our last webinar for this series. We will have more in the fall, but tell us what's coming up.
Hey everyone, it's true. Sorry you can't see me, but I'm here, I promise. We have a few upcoming restorative justice trainings we wanted to tell you about. We'll have 2 courses in the Summer Peacebuilding Institute in Harrisonburg, Virginia at Eastern Mennonite University. There's Restorative Justice, The Promise, The Challenge with Krause and Lorraine Stutzman-Omstutz. That runs May 16th through the 24th. And there's a class called Building Justice, Transitional and Indigenous Applications in Post-War Context. That's looking at the intersection of restorative justice and transitional justice. That's again with Carl Stauffer and also John Cocker from Sierra Leone. June 6th through the 14th. You can learn more about both of those courses and register for them at the website that's listed there. If you have trouble with the link, you can copy and paste it into maybe Brian can copy and paste it into the chat window as well. And then the STAR training that it was mentioned several times in today's webinar, there are a few upcoming opportunities to participate in that as well, the level 1 version. Again, during SBI, there will be a course from May 27th through June 4th. There will also be one June 12th through the 15th in Lancaster, Pennsylvania, and June 24th through the 28th in Washington, D.C. So to learn more about trauma resilience and tools for working with trauma, you can register for that class, again, by following that link. And then we will have several more webinars, I'm sure, in this coming fall. Stay tuned, and you'll be able to learn more about those. Thanks, everyone.
And thank you, everyone that's joined with us today. Yes, we do plan some more. We have Michelle Alexander is probably going to be one of our guests in the fall. We will probably plan about one a month again. You can keep track in various ways, including by checking our website. We'll be posting those before too long. And we try to post the recordings of these transcripts for you to view later as well. So thank you for joining us, and I hope you have a good evening. Good night.